This meeting is now being recorded.
Well, good evening. Welcome to the EDS Awareness Educational Series webinar. My name is John Furman. Before we introduce our speaker this evening, I'd like to give an overview of our free program for those attending for the first time. So we'll go over who we are, what is our program, some upcoming events, introduce our speaker for this evening, Kathleen Kane, and then we'll have a Q&A session. So again, my name is John Furman. I manage the National EDS Awareness Program based in Cincinnati, Ohio. My daughter Deanna leads the Cleveland, Ohio EDS support group. She was diagnosed with EDS in 2008, the same year my wife passed away with breast cancer. I was a caregiver for my wife who struggled with undiagnosed EDS for over 30 years. We introduced our program at the 2012 EDNF conference to help EDSers form independent local support groups and spread EDS awareness in their communities. We've started over 60 groups to date. Each group is given their own free website with a link from the directory and map. We receive feedback from these conferences that they provide valuable information and social opportunities that many cannot afford physically or financially to attend in person. So we've decided to bring the speakers to you through the free EDS Awareness Educational Series. We meet every first and third Wednesday, typically at 7:30 p.m. Eastern Standard Time. All of the programs are free. The meeting announcements and whenever possible, the webinar recordings will be posted on our website at edsawareness.com for later replay. You can receive email announcements for future sessions by requesting the free report on our site. Tonight's presentation is sponsored by Body Support Store, where you'll find over 250 products selected by EDSers for EDSers. The store is the only funding for the program. It usually covers our monthly web fee. So please check it out. This is our store, and you'll find a number of helpful products that we sell. So just a general disclaimer, this presentation contains general information about EDS. Members of the EDS community voluntarily participate in this program. The information is not advice. If you are having medical problems now, please call 911. Always consult your doctor before making any changes to your medical treatment.
Wanted to tell you about some upcoming events, and the next webinar is on October 15th, which is a Wednesday evening at 7:30 p.m. Eastern Time. Our presenter is Dr. Dar. She is the Medical Director of Genetics at Baylor College of Medicine in Houston, and her topic is Coordination of Care in Adults with EDS. And I wanted to let you know that the EDNF is also sponsoring a webinar coming up on October 9th at 8:30 p.m. Eastern Time. And the presenters are Dr. Peter Rowe and Dr. Satish Raj. And their topic is connecting the dots between EDS and POTS, or postural orthostatic tachycardia syndrome. We also had a presentation in the past by Dr. Rowe, and you can listen to that presentation by going to edsawareness.com and clicking on the webinars tab and looking in the past archives. And I just wanted to remind you that tonight's presentation will have an opportunity for Q&A. And you can add your questions at any time during the presentation by clicking the Q&A icon located at the top of your screen. After typing your questions, click the orange button to submit. Our speaker tonight is Kathleen Kane. She will discuss the Social Security disability application process and factors that EDSers should consider when filing for disability. Kathleen practices at the Spillane Law Offices in the Boston area. She graduated cum laude from Widener University School of Law while working full-time. She received her Bachelor of Science in Business Management from St. Joseph's University, and she is a member of the Massachusetts Academy of Trial Attorneys. So welcome, Kathleen. We're looking forward to your presentation, and I'm going to go ahead and turn over the microphone to you.
Okay, thank you very much, John and Deanna. I'm just waiting to load my presentation. I have represented a number of people with connective tissue disorders, of course, including EDS, Marfan syndrome, Loeys-Dietz, Stickler syndrome, and Turner's syndrome. So I hope I can give some, pertinent information about getting through this process. John, you have to remind me how to get to my next slide. There we go. One of the first things I should mention is that we're going to talk about Social Security disability through the federal government, but one of the things that you should also consider is that if you are still working at this point in time, that there could be a chance that your company has a disability policy. So you should check with your human resources to determine whether or not that's something that's available. In terms of the Social Security system, there's basically two different programs that are available.
Did you find the little arrow at the top, Kathleen, that goes to the right? It's in the upper left-hand corner. Okay, hang on. Let me... That was my issue, and you should see it now.
I have it now. Thank you.
Sure.
So the first thing that I think is important is basically making the decision whether or not to file. And why that sounds like something that is fairly easy, it can be quite difficult at times, especially for someone who's worked and who has a career and is getting a lot of has been successful and gets a lot out of their career. I know my husband John actually has Marfan syndrome, and he applied for disability about 10 years ago, and he was an executive at the time. He had a significant income, and it was a really, really difficult decision for him whether or not he was going to apply for Social Security disability. He had a successful career, and he didn't want to give that up. But he also had to take into consideration what his health was and what working on a daily basis was doing to his health. So he was you have to weigh all of these considerations. And of course, one of the, I guess, probably most important considerations is financial. Social Security disability, and we'll talk about the two different types of programs, but they can have a monthly income anywhere between $760, $70, depending on the state that you're in, to approximately $2,500 a month. So for someone, again, who has had a successful career, is making a lot more money than that, has a family to support, has financial obligations, that's something that is extremely difficult sometimes. But again, the thing that you have to balance is what exactly how your health is suffering, and what it's doing to deteriorate your health. These connective tissue disorders, of course, are progressive, so most people, as they age, are finding that they have more and more problems, not that they're necessarily getting better. Hopefully that's something that can change in the future, but it's again, something that has to be considered. And it looks like there's one slide missing, so I'll just kind of go over that. There's two different types of Social Security through the government. One is called Supplemental Security Income, or SSI. The other is called Social Security Disability Insurance. Now, basically, the definition as to whether or not you're disabled for both of these programs is the same. The difference is that SSI is for people who have not necessarily worked. It's also a program for children that are disabled. It is, however, based on your income and assets. So you have to have basically a low income and little or no assets in order to be eligible for SSI. SSDI is a program that is for people that have worked and that have put into the system. So basically when you get your paycheck and you have money that goes from your paycheck into Social Security, it's not only for your retirement Social Security, but also if you become disabled. So this does not have any bearing on what your income or assets are. It's just how long you've worked, how much you made, and what your work history is, whether or not you've had enough what they refer to as quarters in order to be eligible for SSDI. SSI is usually a low amount, again, somewhere between $750 and $800 a month, depending on the state that you live in, whereas SSDI is more than that and can go up to approximately $2,500. You can find out how much you would be eligible for if you have worked in terms of SSDI by ordering one of your statements from Social Security, and you can go to www.ssa.gov and you can order a Social Security statement, and it will reflect on there how much money you would be eligible for if you were deemed disabled, when you retire at 62, when you retire at full retirement age, and when you retire at 70. So if this is something that you're considering, that might be important to see how much you would actually be eligible to receive. The process of filing can actually be done a couple different ways. It can be done on the computer, or it can be done in person by going to your local Social Security office. In terms of applying online, again, you go to ssa.gov, and there is a link to applying for disability. The questions that they're going to ask are going to pertain to your work history, first of all. They're going to want to know the last 15 years of where you've worked, what you did, and approximately how much money you were making for each of your jobs the last 15 years. Most importantly, they're going to want to know all of your medical information. So all of your doctors, all of your hospitalizations, all of your medication, anything that's relevant to whatever disease or disorder that you're claiming is making you disabled. So you should be prepared with all that information if you're going to do it on the computer. There is a system so that you can begin the application and then go back in, so you don't have to necessarily do it at one sitting, but you should have the information ready. In terms of applying in person, I always tell people just don't show up at the Social Security office that you want to make an appointment. And again, if you go on to ssa.gov, they have a toll-free number. You can call that toll-free number and they will make an appointment at your local office. And again, you're going to have the same information available. Everyone always asks me, well, which is better? And it's basically just, if you're comfortable with the computer, that's probably, the easiest way. In person, if you're lucky enough to get someone in the Social Security Administration that, you can sort of advocate your position, then, that could be helpful. But, of course, you never know what you're going to get when you go into the office. When my husband went through this process, we kind of sat down and decided things that we thought were important in the beginning, because, again, sometimes this process can be quite lengthy. So in order to, try to get an approval as quickly as possible, we came up with a list of things that we thought were important and that could help. They're going to ask you to fill out a whole bunch of forms, and usually it seems like you're filling out the same forms all the time, but you have to. If you don't, it's certainly going to hurt your application. If there's a form that's not filled out, your application basically goes to the bottom of the pile. One of the things that you don't want to do when filling out these forms is show yourself as the best that you are. Obviously, you want to be able to communicate as effectively as you can through written words what your problems are and what you go through on a daily basis. I just as an example, I had one client who was denied originally, and we went over his forms, and he put in the forms that, on a daily basis, he takes his children to school and picks them up, and then he runs errands, and then he goes and takes them to after-school activities, et cetera, et cetera. And I said to him, well, how do you feel after you've done all this? And his answer was, well, I can't move for 3 hours, But he didn't put that on the forms. All he did was put all the things that he could do. And this isn't the time to be, strong and I can do anything. It's the time to try to, effectively communicate, what you can't do. You should, look at your individual state program to see if there's any funding that's available, because again, you're talking about a period of time that you're probably going to have, financial issues. So if that's the case, there's, here in Massachusetts we have transitional assistance money that, and food stamp money that is available if you don't have any other household income. Support letter is basically what we do in the Mark Ann Foundation is they actually provide a letter after someone has been denied from the national organization, just explaining what Mark Ann's is, and if we could maybe get one of the EDS organizations to do something similar, it might be effective. One of the things that is important is, and I think this gets into another one of the points here, is that EDS is still a rare disorder. Most people, and I'm sure everyone has come across this, if you say that you have EDS, they have no idea what you're talking about. So anything that you can do to educate the Social Security examiner is important. Okay, so a letter from an organization would be helpful. I always tell people to get some research off the internet or off one of the organization sites that explains what EDS is and submit that. It's very unlikely that someone in the Social Security Administration, especially at this first level, is going to take it on their own to actually do research as to what EDS is. So, be your own best advocate and, try to submit that, in the beginning. You want to make sure that they have your medical records. Now, what will happen is when you apply, they will actually have you sign an authorization for them to get all of your medical records. But anything that you have, you should submit up front. Again, you don't want to put that burden on someone who is maybe not that interested in your particular case. Again, you have to advocate for yourself, and making sure that the records are complete is extremely important. I mean, I had one person with EDS that I represented, and we realized that she was denied originally, and we realized that one of the records that they did not look at in the beginning was, a record from Dr. Frank Amato, and, obviously that was quite important, but for whatever reason, someone in Social Security hadn't taken the time to request it, and it wasn't in there, so that's important. Your doctor support is extremely important, and I have here doctor support letters. First of all, just aside from a letter, if you're going to go through this process, you really have to make sure that you have a doctor who's supportive, because if not, it's going to be more of an uphill battle than could be. And truthfully, I always tell people if you don't have a doctor that is supportive and who understands and who, agrees with your decision to go through this process, then, you should maybe look for another doctor because, the doctor, the medical records, the doctor's evaluations are really key in this process. And if you don't have it, again, it's going to be an uphill battle. A doctor does not have to specifically say that you are disabled, quote unquote. As a matter of fact, the Social Security Administration's position is that it's not a doctor's purview or job to determine who is or who not is disabled. It is the job of the Social Security Administration. A lot of times people will say, well, my doctor put in a letter, a couple lines that, I'm disabled. And that's good and it can be helpful, but it could not be helpful in a lot of situations. What you want from your doctor is for him or her to be able to basically explain what your limitations are, okay? And I actually have forms that I use where it's kind of like a checklist of what he or she feels you can or can't do. And I always explain to doctors that, what you should do in filling out these forms is, take what subjectively your patient is telling you, and as long as, objectively, medically, you feel that it's consistent, then that's something that you have to reflect on the forms. Whichever way, your doctor's support is really key in all of this. And the last thing is, and I think this is important, a daily journal. And what I tell my clients to do is, basically just on a daily basis, write down how you did that day, how you slept the night before, what your pain level was, what your fatigue level was, what you were able to do or not do. Basically, I don't necessarily give this journal to the judge if it gets to the hearing point, but it allows you to be able to, again, express pretty specifically what exactly you go through and why you're not able to work on a daily basis. And truthfully, I know that my husband finds it's important with the daily journal just in terms of his overall, medical history. He can kind of determine what days are good and what days are bad, and if there's something that affects a certain day. Does travel affect? Does food affect? So this can be pretty important, but it definitely helps if you get to the hearing stage because you have something to be able to sort of say, reflect on and be able to testify to what you go through and what limitations you have every day of your life. So basically at the first level that we're talking about now, I have here early approval is possible. What the Social Security regulations have is what they call a listing of impairments. Okay, so these are diseases or disorders that if you fit into their definition of the disease or disorder, then you're probably going to be automatically approved. Okay. EDS is not in the listing of disorders. Okay, and there's a lot of rare disorders that are not in there. All right, unfortunately, Marfan's actually is in the listing of disorders, but only very, very generally, and most of the time, it's not really effective with helping people with Marfan's get approved up front or at the first level. Just to give you very, very generalized statistics, and they change every year, but they basically, it's something like 25% of people are approved at this first stage. And usually it's those people that fit directly into that listing of impairments. When you go to the reconsideration phase, which we'll talk about next, it's like 10 to 15%. And at the hearing level, unfortunately, it used to be something like 70%. Now it's more like 50%. It's gotten a lot tougher, and we can talk a little bit about that later. So all is not lost if you are not in the listing of impairments. If you're not in the listing of impairments, then the Social Security Administration looks at what they refer to as your residual functional capacity. And, I have the definition from Social Security there on my slide. And basically, they're supposed to look at all of your limitations, okay, and again, both physical and mental, and decide whether or not, with all of those things, that you could work and have substantial gainful employment. And when I say work, that's basically working, 40 hours, 5 days a week, okay. A lot of people always ask me, well, can I work when I'm applying for Social Security? You can work a little bit. You can't make more than $1,000 a month, or else you're not going to be deemed to be disabled in that particular month. $1,000 over, that's sort of like the cutoff. So you can do part-time work, and I've certainly had clients that have had part-time work that were then also approved for Social Security disability. But again, it's not a lot. In terms of the residual functional capacity, this is, when you think about it, it's somewhat of a subjective standard, and this is where, advocating for your position and having, if you get to the hearing point, having a good presentation to the judge, is very important. The other thing is you want to include everything that you suffer from. So, a lot of people originally just might say, well, I have EDS, which is fine, but, if you have someone who is not going to do the research to see what EDS means, then that's not going to mean very much. So you want to specifically go through each and everything that you suffer from. So I have EDS. I also have POTS. Always include any kind of, mental disorders that you have. Let's face it, most people that have chronic pain also, suffer from depression at times, anxiety. So those things can be important as well. So you want to include everything, not just what you consider, your main disorder is. So basically, there's a couple different stages getting through the Social Security process. We talked about the first stage, where basically you apply online or in person. You usually will get an answer within 3 to 4 months as to whether or not you're improved. If you have been denied, you go to what we call the reconsideration phase. And reconsideration is basically just another level in the Social Security Department looking at your case and deciding whether or not the first decision was correct. Again, not very many people are necessarily approved at reconsideration. After that, and it's probably another 3 months until you get that decision, reconsideration decision. If you're denied, then you have to appeal and ask for a hearing in front of an administrative law judge. This is the most important, I believe, part of the process. You're actually going to be in front of a judge, and we'll talk about the hearing a little later, but this is where you can win your case. So it's very important. If you are denied at the hearing, they have what they refer to as an appeals counsel. The appeals counsel, people usually are not successful at appeals. They're looking to the judge at the hearing level to make decisions concerning credibility and factual decisions. So the appeals counsel is probably only going to overturn or remand your case if there is a significant legal issue that the hearing judge was wrong about. I mean, it is possible, to have your case at the appeals level remanded for another hearing. But again, like with most appeal situations in our court system, it's not always successful. If you're denied by the appeals counsel, you can actually then go into a United States District Court and eventually take it up to the Supreme Court of the United States. Again, when you're in federal court, you're talking about a significant legal issue that has to be apparent, or else you're probably not going to be successful at any of those levels. If you are denied at the hearing stage, you can also begin again the whole process and apply again. if you decide not to go to the appeals council. And, depending on the judge's decision and his opinion, that's sometimes, what I suggest to a client. So the administrative hearings, again, they're in front of a judge. They are not what we refer to as adversarial, so it's not like what you see on television. There's no cross-examination. The judge is supposed to be trying to get information from you, as opposed to, again, being adversarial in any way. With that being said, some judges are still adversarial. It's extremely important that you're prepared. Okay, you have to have all of your medical records. Nowadays, if you have a lawyer, you can actually get your Social Security file electronically through the Social Security Administration, so you can make sure that everything's there. If you're representing yourself, they'll send you a CD with all of your medical records and all the other documents, so you can make sure that everything is there that you feel is important. You are allowed to have witnesses. Again, whether or not that's appropriate, sometimes I feel it is, sometimes I feel it isn't. If you have someone who is, able to communicate effectively about their condition and about what they go through, then, witnesses probably aren't important. However, if you're not able to, then, a witness is important. When I say witness, I'm usually a family member, a spouse, a friend. Judges, sometimes they are okay with witnesses. Sometimes they're like, well, witnesses, just saying the same thing that you said, so they're not really taking them that much in terms of having that much weight. But again, it depends on the situation. It depends on the judge. A judge can decide to have a medical expert there. It doesn't happen often. When it does happen, the medical expert is usually testifying via telephone and not there in person. And I always like to have a medical expert because I feel that going through representing people with connective tissue disorders and going to all the medical conferences, I feel like I know a lot about these disorders, and probably more than your average primary care physician, which is usually what the medical experts are. When I say experts, they're not going to have someone who is an expert in EDS testify at your hearing, believe me. Vocational experts are usually at the hearing. Our vocational expert is there to basically testify based on your testimony what jobs he or she believes you're able to perform in the national and local economy, and whether or not you're able to perform your previous type of work. Vocational experts can be cross-examined. So basically what happens is after the claimant testifies, the judge gives what they call a hypothetical to the vocational expert. So they basically say to the vocational expert, if you take someone of the claimant's age, work experience, education, et cetera, and put the following limitations on them, would there be jobs that they can perform? And sometimes there are, and sometimes there aren't. And, again, you can cross-examine the vocational expert as to, what they're, and again, it usually happens when you have an attorney, but that can be important because if a vocational expert says that there are no jobs that you can perform, then you're going to be approved for benefits. So the administrative hearing is very important. And by the way, it's usually in a very small room. Again, the judge sits a little higher than the rest, but it's not a courtroom like you're used to. And it would only be the claimant, an attorney if he or she has one. The judge has a clerk who is basically making sure that the hearing is actually taped, audio taped. So they're making sure that the audio tape is coming through and everything's okay with that. And a vocational expert or a medical expert if there is one in this particular hearing. There's no other outsiders allowed, so, in that way it's somewhat informal. However, you are under oath. The judge is there to hear testimony, to receive evidence, and to judge your credibility. So an administrative hearing can be very important. If you decide to hire a lawyer, the Social Security Administration actually has regulations in terms of how a lawyer can be compensated. And basically they would get 25% of your retroactive payments, maximum of $6,000. What I mean by retroactive payments is that one of the determinations that the administrative law judge is going to make, or wherever in the process you're approved, one of the determinations is when you were deemed disabled. And sometimes that's an easy issue. It could be the day after you stopped working. So the date that you're deemed disabled, you're basically going to be eligible for benefits from that date until you're approved, okay? And, minus 5 months in the beginning for, again, just for different regulatory reasons. So you could be eligible for quite a bit of retroactive payments. This process, can take long sometimes, and when I say long, years. At this point in time, we talked about 3 months originally for the first application, then another 3 months for the reconsideration, and then when you apply for a hearing in front of a judge, it could be a year or more. It depends on what part of the country you're in, and there's some parts of the country that are a year and a half, 2 years, okay? So you're talking about a pretty lengthy period of time, and if you're eventually approved for benefits, then you would get all of those retroactive payments. And again, the attorney would be responsible or would be compensated by receiving 25% of the retroactive payments. And that's contingent, so if you're not successful, then the attorney doesn't get anything. And again, it kind of makes sense because, most people, if they're going through this, don't have the funds to pay a lawyer hourly or upfront to take on a case. And if a lawyer tries to charge you any other way, then they're not correct. In terms of hiring a lawyer, I always tell people, I don't think it's necessary upfront to hire a lawyer. Basically, when you first apply, the Social Security Administration is going to just gather all of your information. And, truthfully, a lawyer has very little opportunity to advocate or to do really anything on your behalf. I mean, obviously, if you want a good submission, up front, then, there's people that can help you with that. My husband, John, is a Social Security advocate, and he helps people for free at the first couple stages so that they won't have to pay a lawyer. And at the reconsideration, it's basically sort of the same thing, that you're probably not going to get much benefit from hiring a lawyer. The Social Security Administration employee that's working on your case will probably not be in contact with your lawyer, unless he or she is looking for a certain form or a document. But there's not too much that a lawyer can do at the first couple stages. And I guess the only time I would say that that's different is if you really have someone who, for whatever reason, whether it be just, anxiety or just really has a difficult time with documentation and paperwork, then, you might need someone to help you. But for the most part, that's not the case. When you go to a hearing in front of a judge, I think you do need a lawyer. Again, it's a court of law. There's a judge there. You're under oath. There's going to be evidence. There's going to be cross-examination. And so, I mean, I think it's probably important. When my husband John applied, I told him that he needed to get a lawyer, and it wasn't going to be me because, you know, I was too close to the situation. Luckily, he was approved at one of the early stages, but you know, I think it's important to have that kind of you know, professional representing you at that point. One of the other things I mentioned, you know, I always like to kind of have realistic expectations set, and for whatever reason, this process has gotten a lot more difficult, and the percentage of people that are being approved has dropped a lot, a lot. As I said, I think that it used to be statistically only about 5 years ago that at the hearing level, over 70% of people were approved for benefits. Now it's more like 50%, and that's across the country. And it depends on, you know, what part of the country you're in, depends on what office you're in, depends on what judge you have. And, you know, unfortunately, you don't get to choose any of those things. I had a judge, I was in California yesterday, and I had a judge who only approves 26% of the cases that are before her. Okay, so obviously that's going to be, you know, a tough one. But you can't choose your judge, so you just have to put forth the best case that you possibly can. And again, you can always, if you are denied at a hearing, you can always apply again. You do not get the same judge, you know, which can be a good thing. But it's, you know, it can be a difficult process. So I think that's all that I have. And
okay, great. Well, that's fabulous information that we can all use in filing for the disability, go through the disability process. So what we could do now at this time is click on the Q&A button at the top, Kathleen. And as I mentioned before, there should be a little arrow down at the bottom, and it's easier as you're scrolling through to use that rather than the scroll bar. So if you'd like to start out, that'd be great. Thank you.
Sure. So the first question is, does my net worth affect my ability to qualify for disability? I was only able to work for a year. I think I mentioned in the beginning the difference between SSI and SSDI. With only 1 year of work, you're probably not going to be eligible. You're not going to be eligible for SSDI. That's the amount of money that you've put into the system. So therefore, you would have to try to be eligible for SSI, and SSI is based on your income and your assets. So your net worth does go into it, and basically you can't have more than $2,000 in the bank. So unfortunately, it's probably going to be a problem for you. The next question, this person has only worked in the U.S. for 4 years, not a resident. So basically 4 years is probably not enough time. What I would do here is I would contact Social Security, make an appointment and go in, and they'll tell you exactly what you're eligible for. And again, don't just show up at the office, definitely make an appointment. The next question is, my lawyer suggested getting an exam called Functional Capacity Evaluation Test. And do I feel that the exam is worth getting? So this can be a good or a bad thing. Obviously, if the functional capacity evaluation comes back positive, then it's something that, you know, is good and that you can, you know, you could certainly submit. If it's not, then, you know, it's not good to submit. The other problem I sort of see sometimes with this is that it's been my experience that a judge is going to put more weight on one of your treating physicians as opposed to someone who's only seen you once. However, with all that being said, if your lawyer is suggesting this, he probably knows the particular office that your hearing is in, and I would certainly, weigh heavily on what his suggestion is. Next question. I wanted to know if there's a way to figure out how a homemaker can apply for disability using her husband's credits, especially if one of the primary reasons she stayed home was in order to manage home responsibilities so he could advance his career, thereby making a higher income and paying more into Social Security. After age 55, if your husband is deceased, you would be able to get widower benefits, and you would be able to basically get benefits based on what he has put into the system. But other than that, no, there's not. If he's still alive, then there's not going to be a way to do that. And I'm assuming if he has a substantial income, then that your household income would basically not allow you to be eligible for SSI, because SSI, when I say income and asset-based, it's not you individually, it's the household income. Next question, can you still receive disability if you're only physically able to work part-time? Again, the standard is if you're making less than $1,000 a month, then the answer is yes, okay? But once you are over 1,000, then they're basically the regulations say that you have, you're not disabled if you're making over 1,000 a month. Next question is, what happens if someone is moving to another state while the disability case is still under review, and what happens after it is approved and you move to a different state? So after it's approved and you move to a different state, that's not a problem. Remember, this is a federal program, so basically, if you're approved for benefits, then the benefits are going to follow you wherever you go. If you're in the middle of the process and you move, it becomes a little more complicated. What I've seen happen is a couple different things. If you're very close to a hearing and you've decided to move, the hearing can be transferred to your wherever you're moving, the closest hearing office. However, there's definitely going to be a delay in you getting to the hearing. So you're talking about a longer amount of time. What I've done with clients who were very, very close to having a hearing is give them the option of coming back to their original state in order to have the hearing. And that way it doesn't delay getting a hearing. So it kind of depends where in the process you are. Again, if it's before the hearing stage and you're in the first, you've just applied or you're in reconsideration, you can move it to the new hearing office where you're moving. However, it's not going to be a big delay, but there's going to probably be a little bit of a delay. My daughter, next question, my daughter has not earned any Social Security credit. She has been ill for several years. Can she still file for disability? So basically, children are eligible, and I'm not sure how old your daughter is, but children are eligible for SSI, okay? However, if they're under 18, what's going to happen is they're going to take into consideration the household income. So if the parents are working, chances are the child will not be monetarily eligible for SSI, even though they are disabled. Once a child turns 18, then it's not household income anymore, but it's what the child actually earns. So if they're not working, they would be eligible for SSI. So again, whatever age the child is, once they turn 18, things do change. Let's see. So next question, should we get letters from all doctors or just the ones who are supportive? I would say just the ones that are supportive. You're going to need to get medical records from all of your doctors, but obviously a letter or a form, you want someone who is going to be supportive. And for the most part, if you have one doctor who's supportive, that could mean the difference. The next question is, I have been denied twice and I'm waiting on the hearing. I also had open heart surgery twice. Need to have it again soon. I have many other diagnoses. I'm 50 years old. My attorney hasn't heard of EDS before. Any suggestions? Cardiologists, rheumatologists are on board to speak at hearing if needed. So first of all, once you're over 50, it does get easier. So that's the good news. And I mean, truthfully, if you have doctors who are willing to testify, then you are so lucky, because that is very, very rare. It would probably be enough just to have them have forms filled out, saying or explaining what your limitations are. But if they're willing to be there, then you maybe have a home run. I wish I had that sometimes, but so good luck with that. Okay, so where can I get a list of approved conditions? If you go to SSA.gov and put in the search engine listing of impairments, it will bring that up, and basically it goes by body system. So there's cardiovascular, neurological, et cetera, orthopedic. Some people with EDS who have pretty severe joint issues or hypermobility, they may fit into something in the orthopedic listing of impairments, but that's going to be, you'd have to look at it and, see what your doctor thinks. But it doesn't happen a lot. Okay. I have been on disability from a private policy since 1995 for loss of hearing. I was a court reporter. How does this affect applying for Social Security disability? Just realized in the last week that all the other physical problems in my life were due to EDS, and had no idea now that this is what I have. I have worked part-time. Hold on for one. Lost it for a second. Just bear with me. I've worked part-time, online at home, helping my brother's business, but it's around $1,000 a month, so probably qualifies as minimum. Social Security online says I can apply for Social Security. So basically, the problem you may have there is just that your work history was so long ago, so you might not have enough credits to be eligible for SSDI. Again, SSI, maybe not either if you have a private insurance policy. So again, I would probably take the time to make an appointment with Social Security, and they'll be able to look at your record and tell you specifically if you're eligible based on what you put into the system, and obviously how much you'd be eligible for. Next question. Can you find out what the psychiatrist or another doctor hired by the SSA said about you? Yes. Basically, just so everyone knows, sometimes Social Security will send you for what they refer to as a CE, or consultative examination. And this is a doctor who is hired by the Social Security Administration to evaluate you. Again, the key being hired by the Social Security Administration. They're supposed to be objective, but, that's questionable sometimes. Yes, your CE evaluation is part of your record, okay? So it should either be, if you have a lawyer and they have access to the online system, then you can get that way, or it should be on the CD that they sent you. I'm not sure exactly where in the process you are, but your CE, or consultative examination, is definitely part of your record, and you have the right to see that, and you should look at it if you have any questions. The next question, under the SSA list of impairments for musculoskeletal and dysfunction of the joint, could instability of the cranial-cervical junction and key area put in that category? Yes, and I have seen that. Again, if you could get a doctor to say that you meet the listing based on the exact wording of the listing, then that would obviously, be helpful, because you have to try to sometimes spoon feed the Social Security examiners the information that they need to approve you. The next question is, as far as doctor support letters, I have had doctors for all the problems individually, knees, eyes, ears, neck, etc. But no one doctor says as a whole that this is EDS. I have a rheumatologist scheduled appointment in a week, so hoping that that can be that person. Any words of advice on how to address with him when I meet him? So I guess the key is going to be if he's familiar with EDS, and obviously some rheumatologists are and others aren't. One of the things that I always tell people is, especially in this process, don't be so concerned about a diagnosis. It can be important, and sometimes it's important just for yourself to know. But this whole procedure and process and what the Social Security Administration is looking at is all about what your limitations are, whether they be physical or mental. So you need to have doctors say that, for instance, because of your knees, you can only stand so long. Because of your eyes, you could only be on the computer for so long. Because of your ears, you couldn't be a receptionist, or you couldn't, you couldn't be on the telephone for that long, et cetera, et cetera. Okay, so that's what's basic. That's the key. That's what's going to get you eligible, because they're basically saying what the evaluation is how long can I sit, how long can I stand, how long can I keyboard, how long can I manipulate machinery, and if those things are somehow impacted by whatever disease or disorder that you have, then there's not going to be jobs that you can do. And that's really where the key is. It's not having a firm diagnosis. But obviously, if your rheumatologist is familiar with EDS and can make that determination, then that's terrific. Next question is, at my hearing 18 months ago, I was denied the opportunity to have a witness or even family present. I did have a medical expert testimony by letter. The hearing was very adversarial, and she denied my claim. I've been waiting for over a year for an administrative appeal date. How can I best advocate myself at this stage? You don't say here whether or not you had a lawyer, first of all. If you were denied the opportunity to have witnesses, that could be problematic as far as the appeals council is concerned. Don't get me wrong, there's judges that will make it very, very clear that they are not interested in having a witness. But having a right of denial could be problematic. The judge does not have to accommodate you by having a family member present. Most do, but that's not something that is going to be a problem with the appeals council. And again, the hearing should not be adversarial in any way, but there are judges that are extremely adversarial. And if it's apparent on the tape, then the appeals council could certainly remand the case. In terms of how you can best advocate yourself at the appeals council, the only thing you can really do is make sure that if there's any new information that they have it, and if you have a lawyer, I'm sure that they've submitted some sort of statement or memo concerning what they thought was wrong at the hearing. And if not, then you could take it upon yourself to do something and just put down in writing and send it to the appeals council what you feel was important. And, hopefully, remember the appeals council, you're not going to get any kind of, you're not going to have a hearing in front of the appeals council. What they're going to do is basically just remand it to the judge, which, by the way, you already had, who denied you. But depending on what the appeals council says, they can, you could certainly have it overturned at that point. And then, P.S., I have an attorney and have paid them already. I didn't see that part. Stacy. Yeah, I'm not sure why that happened, but that shouldn't have happened. Again, the regulations basically say that they should be paid out of your benefits when you're approved in your retroactive benefits. Next question, I have an additional disease, an autoimmune called Sjögren's. Does the rheumatologist need to use the term, or can she just say dry mouth and dry eyes? She is supportive and said she would fill out any paperwork needed. She doesn't necessarily need to use the term. Again, it's all about what your symptoms are, what your limitations are, and why they cause you not to be able to work. So that's fine, and it's good that she's supportive. The next question, if you were self-employed and there's not an exact date of when you stopped working because you started lowering your tasks, but your taxes showed you did not end up getting income, can you change the date you said you stopped working? So basically what they're going to look at, the Social Security Administration, is when your income stopped. But if you were self-employed, I'm just wondering, were you taking out Social Security? But their thing is, when was the last quarter that you actually had reported income? The next question is, are your chances better of being approved if you have a lawyer file? And I think I addressed that. I don't think it's important in the beginning. I think once you go to a hearing, it can be very important. But when you're first filing, as long as you're very conscious of getting all the information, and I provided a checklist at the beginning of other things that might be helpful. It's not really necessary to have a lawyer, but the hearing, I believe it is. If a young adult is filing for SSI, would childhood medical history records be relevant? They could be. Again, it depends on how old the young adult is. And, but I would say, I usually like to, go back a few years with medical records. And then if there was something that was extremely significant, you might want to get those records. But it's not like you have to go back through their whole childhood. That's certainly not necessary. And as you probably realize, with medical records, they usually will repeat whatever diagnosis or surgeries or medical treatment that you've had. So even the recent ones would reflect things that happened in the past. Next question is, I'm applying for my 17-year-old daughter. She has EDS, POTS, gastroparesis, abdominal migraines. If she doesn't get approved before turning 18, how does that work then? Because she will be an adult. Do we have to start the process over? So let's see, she's 17. So if she is eligible at 17 based on her household income, forget whether or not she's deemed disabled, then it's fine. She would just continue. If she's not eligible at 17 because of her household income, her parents' income, then at 18 she would be because she's an adult and it just goes to her individual income. The next question, is there a time period you have to fill out the forms? Not particularly. I've had the forms submitted to the judge, the day before the hearing. So, on the other hand, you want them to be somewhat recent. So, for instance, I usually wait a couple months after applying for a hearing to get a form filled out. That way, it's close enough to when the hearing's going to be to still be relevant. But there's actually no set time when they have to be filed. You said that you can't work while applying for disability. Is that right? How long do you have to be out of work before you apply? Are my spouse's earnings put into account? So basically, you can work, but you have to be making less than $1,000. So if you're making more than $1,000, then you're not going to be deemed disabled. In terms of how long you have to wait before you're out of work to apply, you can apply the next day. Okay, so if you stop working on Tuesday, you can go into the office on Wednesday and apply. And, that Wednesday will be the date that, you're deemed disabled if you're eventually approved. But if you're making more than $1,000, then they're not going to deem you disabled. In terms of your spouse's earnings, they're going to be taken into account for SSI. And that, again, because SSI is the household income and asset. So if you have a spouse that's working, then you're probably not going to be eligible for SSI. SSDI, of course, is based on what and if and what you've put into the system through your work career. So despite what you or your husband make or have in assets, then you would be eligible for SSDI if you have enough quarters. My spouse has an IRS lien on his property. Does that affect my ability to qualify? No, I can't see any reason that would be the case. The next question, I actually filed for disability 2 days ago while I was at the Social Security office for a family member. I was lucky enough to have visit summaries from several of my docs. Should I take the caseworker summaries from the rest of my docs? I see 8 different physicians. To have visit summaries. Yeah, any and all information that you can get to make your case stronger. So any doctor that you can get to support you in any way is going to be important. Next question, is it easier to get SSDI if the person is over age 55? How about 60? The person has worked 37 years. Yes. After age 50 it's easier, and then after age 55 it's easier, even easier. And 60, you're 2 years to Social Security retirement, so they're probably going to approve you. But yes, after 50 it's easier, and after 55 it's even easier. I've applied and I'm waiting for my decision. I really can't work at this time. Dizzy constantly with POTS. Do you know if New York has the transitional income that you mentioned, and how do you apply? I would assume that New York State would have something. I don't know for sure offhand, but I would think that they had some sort of transitional income program. I would get on the internet, and usually it's county-based. So, go to your county and, look up something, just Google transitional income. And if I had to guess, I would think that they certainly have something like that. Does veteran status affect SSDI in any way? The only way that it affects it is if you receive a veteran's disability income. Depending on what type it is, then there can be some sort of offset once you're approved for SSDI. And it's somewhat complicated, but other than that, the veteran status would not affect it. Next question. In the first stage, I was pending a small fiber polyneuropathy diagnosis, and since I've been diagnosed with it and sent paperwork in, I'm now in the reconsideration phase with having done one of the acceptable disorders. With now having one of the acceptable disorders, that will make it easier to get on SSDI. I don't know offhand if that's one of the acceptable disorders. If, again, you go to a SSA.gov and do listing of impairments, and you'll be able to go through that and see. I don't know offhand. Next question. I have letters to my daughter's school from her doctor stating what is wrong with her and that she will miss school and the accommodations the school needs to give her. Are those letters from the doctors good enough to include in the paperwork? Absolutely. With a child, anything about schooling, missing time, being late, and the accommodations can be extremely important. And as a matter of fact, the judges will ask questions about that. So any documents that you have regarding that are extremely important. Next question. I've been approved for long-term disability through my private insurance disability policy, one I paid on my own. Does this help at all with SSA disability approval process? What Disability or Social Security Administration will say is no, that their regulations are their regulations. In my experience, I will tell you that sometimes long-term disability policies, in terms of getting an approval, can be pretty difficult. So I think not in a legal way, but maybe in a sort of, oh, okay, she got the long-term disability way, that it could be important. If you qualify for SSA at the time of application and the process drags on for years, must you only have income under $1,000 during the entire process? Yes. Well, yes. Technically, if you had 1 month where you made over $1,000, they could disqualify you for that month. But the reality of it is, even if it's a couple months that you're able to make $1,000, then that's going to probably say to the judge that you can work and you're not disabled, unfortunately. What about info from therapists, physical therapists, et cetera? And if you spend a significant number of hours per week at therapy due to surgeries and/or managing conditions, could this be listed as limitations as you are not a reliable employee? Absolutely. I mean, one of the things that is a question that I always ask the vocational experts is if a person misses 3 days a month, or, sometimes I use 4 days a month, would they be able to find employment in, competitive employment? And the answer is no. Okay, so if you can establish that, remember, we're talking the standard here is working 40 hours a week, 5 days a week for the most part. So if you can establish that for whatever reason you're going to miss 4 days a month, then the vocational expert is going to have to say that you can't find competitive employment. Of course, you have to make sure that the judge believes that. But if you have any kind of documentations that you can provide, then that's absolutely important. Next question. Could a judge decide to approve disability as of a different date than the date you submitted based on hearing results? Yes. So basically what happens is when you apply, you're going to have a date where you say that you were deemed disabled. And sometimes at the hearing, a judge will decide that that is not the true date that you were deemed disabled. For different reasons, he decides that there's a different date. So, for instance, if I've seen it in cases where a person stops working, they say that they were disabled as of whatever date, and then, maybe 6 months, a year later, they have something significant happen, whether it's, a new diagnosis or, an operation or whatever, and the judge says, no, I don't believe you're not deemed disabled as of the date that you gave me. I believe you were deemed disabled at that date 6 months later. Should I send copies of MRI, CT scans? The reports are fine. Yeah. In the case of an adult child who is living with parent and applying for SSI, I heard that there may be a special way to apply whereby the child's benefit amount is based on the parent's earnings. So if you can prove that you were disabled, a disabled child before the age of 22, and you have a parent who is either deceased or disabled, then if you're deemed disabled, then you would be able to get SSDI based on the parent's record, okay, which again is actually going to be probably significantly more. And I'll say that again just so I'm clear. If you can prove that you were a disabled child, you were disabled before 22, and you have a parent who is either disabled, him or herself, or deceased, then you can actually get benefits off of their record, which is going to be probably significantly more. Next question. I know that I put in my 40 credits years ago for Social Security, but stopped working in 1995 when I went on to my private disability policy. Your answer a few minutes ago was to check with see if I had enough credits. Assuming it's valid, would Social Security go back retroactively to when I left my career as a court reporter? I'm currently making a little more than $1,000 a month. If it's $1,200 a month, that would be considered not disabled. If I went down to $1,000 a month, that suddenly make me eligible to apply. So, to answer your first question, technically they would go back to when you were, if they felt that you were disabled as of when you stopped working, then they would go back there. I haven't seen that too many times in that long of a period of time, but it is possible. Yeah, I think I read your last question incorrectly. I believe if you're making $1,000 a month on your private disability policy, then that's okay. That's not earned income. So the $1,000 is money from working that you have to have, so you should be okay there. Would data of issued permanent disability place cards be accepted as a disabled date? No, not necessarily. However, what I usually do is if a person has a permanent disability place card, then, I'll put that in as evidence. And the other thing is, I'm assuming if you have one, then a doctor had to sign off on it, which, if that's the case, he should be able to be cooperative in terms of any kind of forms or information that needs to be submitted to Social Security. If your report does not show the correct info because the radiology did not recognize issues like Chiari, et cetera, would a letter from a doctor be better than the actual report from the imaging? Yes, absolutely. If your doctor disputes the radiological report, then, absolutely provide what the doctor says. I think that Social Security Administration is going to put more weight on what your treating doctor says than what a radiologist says, especially, who's seen you one time. My case has been sent back to federal court. Do I stand a chance? And you always stand a chance, absolutely. And, if your lawyer decided to have your case go to federal court, then I'm sure he believes that you have a good chance there. Does it help or hinder if the case is remanded back to the administrative judge? It depends. That's always the answer, I guess, right? It depends on, first of all, what the appeals council said, okay? And, I think it kind of depends on the personality of the judge. I think sometimes judges are sort of angry that they were told they were wrong, and so they want to, still not approve you, and others are like, oh, well, they said I was wrong. I was probably wrong, so I really should think this through a little bit. So again, it all depends on a judge, and it depends on what the appeals council, what their reason for remand was. Next question. If your family gives you financial support while you're not able to work and applying for disability, does that amount of income count towards the $1,000? No, it doesn't, because that's not earned income. When I say $1,000, it's income that you're earning through work. It happens all the time that, family members provide support, so that's nothing unusual. Next question. I just came in. I have been disabled, but I am a stay-at-home mom. I worked full-time from the age of 17 to 22. So will they look at the years I did work? It depends on how long ago that was, but yes, they will look at that. And again, unfortunately, the only way you can really get a good answer to those type of questions is to go to Social Security, because they have your full record and how much you made and how long you worked, and they'll be able to tell you exactly what you're eligible for. Next question. I stopped working following surgeries, and then about 2 months later tried working 10 hours per week, and then finally quit. Was never making more than $750. I'm assuming my date of disability should be the date of my surgeries. Correct. Again, you weren't making more than $1,000, so you could still be deemed disabled during that period of time. And, it shows that you actually made an attempt, which can sometimes, make a good impression on an administrative law judge. And I think, John, that's all the questions.
Okay. Thank you, Kathleen. I'm getting a bunch of thank yous from the attendees for donating your time and giving us such wonderful information. And
No problem.
I just want to remind everybody that Kathleen is available to take cases, and she's very familiar with connective tissue disorders, so you can look up her information at SpillaneLawOffices.com. It's SPILLANE lawoffices.com, and her email is Kane, KKANE, at SpillaneLawOffices.com.
And we'd like to thank everyone who attended. We had a little techie problem up front, but we had quite a good attendance. We had about 45 questions, and Kathleen was very efficient at getting through those and getting some very good answers. So again, Kathleen, thank you very much.
Oh, thank you for having me.
And just wanted to remind people that our next webinar will be on the 15th of October, Dr. Dar. So please dial in for that. Also, I'd like to remind people that our sponsor is bodysupportstore.com. So please go to our store and look at some of the products we have. So all of them were approved by EDSers for EDSers. So again, thank you all for attending, and we really appreciate you being here for our speaker, and our speaker communicating such good information. The recording will be posted on our site tomorrow, as well as a PDF of the slides. So if you missed some of the presentation, you can play that back, or you can also forward that to other individuals who may have missed this session with valuable information. So again, thank you for your attendance, and we'll call it a night. So good evening.
Thank you.
Good night.
Good night.